Supreme Court Appeal, case number SA 34 of 2018, the Government of the Republic of Namibia versus National Teachers Union and two others.
May it please the court, I
Mr. Bartman.
appear for the appellant, my lords, with my learned friend, Mr. Hengari.
The court. I appear for the first respondent together with my learned friend, Mr. McQuire. My lords, in the normal course, I would have introduced myself before the court commenced. That's not been possible. I approached His Lordship, Mr. Justice Smuts' registrar yesterday to inquire as to what procedure I should adopt, and she suggested I formally introduce myself at the commencement of the proceedings, which I now do.
Thank you. Mr. Bartlander? Yes. Bartlander?
May it please the court, I'm sorry, I was muted, but I've now been unmuted. My lords, are your lordships hearing me?
Yes.
Yes, thank you.
Yes.
Thank you. My lords, there are two interlocutory applications which I propose to address before I get to the merits, and I'll deal with each of them in turn. The first interlocutory application is an application for the admission of the exhibits volume, which was served on the respondent, but in error was not filed at court. The circumstances which give rise to this application are set out in the affidavit of Mr. Ncube in the application which was filed on the 17th of February this year. He explains from paragraph 2 that on the 6th of February, when heads of argument were being prepared, it was discovered that pages of the record were missing. On the 7th of February, paragraph 4, he says that he consulted with me and I drew this to his attention and advised that an application should be made for condonation for the exclusion of the pages and their admission, and that it was accidental, he explains. He then consulted on the 10th of February, the following Monday, with the legal representative of the respondent, who pointed out to me that in fact the exhibits were all prepared, but they were in a fourth volume, and the fourth volume was not in my instructing legal representative's possession. He then the next day went to the court, this court, perused the file, and he discovered that the exhibits volume was inadvertently not found and was not part of the record. And he attaches a copy of that exhibits record, 113 pages. He says that the legal representative for the respondent said that he had no objection to the filing of the missing exhibits record and annexures. And he then immediately filed this application for leave to file the exhibits record, which, as your lordships will be aware, is part of the papers. It's attached to the application. He asked for leave to file those papers. My lords, he points out that the appeal is of considerable importance to the parties and indeed to the public. It involves the question of whether the government is under an obligation to spend a very substantial amount of public money. I'll address that shortly. He points out at paragraph 12 that the respondent is aware of all of the evidence, all of which was before the court or quo, and that he submits that the respondent won't be prejudiced. He says that the exhibits in the record were all used in the proceedings in the court or quo. He apologizes to the court for the oversight and for any inconvenience which has been caused. And then in paragraph 14, he says, I respectfully submit that under all the circumstances, the interests of justice favor the condonation of this oversight. He says, I request that the exclusion of the exhibits record in question be condoned, and that the attached record, that's attached to his affidavit, be admitted as part of the Supreme Court record of appeal. So the facts briefly are the following: that the exhibit volume was timeously served on the respondent, which has at all times been in possession of it, but through an oversight, it was not filed at the court when the rest of the record was filed. It's common cause that the exhibits volume contains all of the exhibits, contains the exhibits, which were before the court are quo, and the circumstances in which the error was discovered in February, on the 11th of February 2020, are fully explained. The application for condemnation was made within a week, on the 17th of February, together with a copy of the exhibits volume. The heads of argument were timelessly filed, and the respondent accepts that it has not been prejudiced in any way. Mr. Ncube says in his affidavit that the respondent's legal representative, Mr. Bierkus, said that he didn't object to the filing of the missing volume. Mr. Bierkus has filed an affidavit in which he says, he confirms that, but he says that he informed Mr. Ncube that he would have to take instructions from his client and consult counsel. And after he'd considered the application for condemnation, the application for condemnation was served on the 17th of February, and the respondent has not opposed it and does not oppose it. So we respectfully submit that it would be in the interest of justice that this application be granted. First, the failure to file a copy of the exhibits volume was the result of a bona fide oversight. Second, as soon as the oversight was discovered 2 months ago, the appellant applied for condemnation for leave to file the volume as attached to the affidavit. The respondent was all along had the full record, and the exhibits common cause that the exhibits volume which was filed is the volume which of the exhibits which were before the court are quo. We recognize the inconvenience caused to the court by the failure to file the 4th volume at the same time as the rest of the record, and we apologize for that. We respectfully submit that there are reasonable and in fact good prospects of success in the appeal on the merits. And we point out, my lords, that this appeal is of major public importance. What the court did, the court are quo ordered the government to pay the incentives in question from the 1st of April 2015, together with interest. I'm not going to go there for your lordship. Your lordships will find that in volume 3, page 339, paragraphs 5 and 6. That's the order of the court. It's an order to pay the incentives in question with effect from 1st of April 2015 plus interest. That's more than 5 years ago. The amount of the incentives, in 2012, the amount of the incentives was 47 million Namibian dollars. And your lordships will find that in the material before the court. It's in the Stellenbosch report, exhibit H1, page 83, line 4. So your lordships will remember the Stellenbosch University carried out a research into the incentives, and they reported that it had cost the government 47 million dollars per year. And so conservatively, over the 5 years since April 2015, the capital and interest is now about $250 million Namibian dollars. 5 years at $47 million plus interest. There's conservatively the amount of $250 million involved. And in addition to that $250 million, under the order, in terms of the order of the court are quo, the government will have to continue to pay approximately $50 million per year going forward, indefinitely, every year into the future. So the amount of money involved, public money, which is involved, is very substantial indeed. It's R250 million plus 50 million a year indefinitely. It's a case with, in other words, with very far-reaching consequences. I have had regard to the judgment of this court, and in fact of this very bench, in the Tweya matter, dealing with late filing of the record. The reference is Tweya, T-W-E-Y-A versus Herbert, NASC, SA 76/2014. As I say, a judgment of this court and indeed this bench. Your lordships may recall what the facts were in that case. In that case, more than 400 pages were omitted entirely from the record. The missing pages were filed only 2 days before the hearing. The application for condemnation was filed the day before the hearing. The third and fourth appellants hadn't filed heads of argument, And the result was that the court was in no
I can't
position.
hear anything.
Just a moment.
My brother on my left
does not hear
anything.
Can I ask, Judge, whether the other people are hearing
Someone
me?
assist here.
Yeah, I'm okay.
Yes.
I'm okay.
Is that okay, Justice Smith?
Yes, thank you. Perfectly clear.
May I proceed, my lord?
Just one more.
No. Just one more. Hello. Can you hear me? Can I have to hear Mr. Butland?
Can you perhaps try to say something?
Could Mr.
Testing.
Butland just say something?
Testing,
Yes,
testing.
yes, we can.
Can your lordship hear me now?
We'll try to leave the meeting and then come back again.
Okay. Okay. Could Mr. Butland just say something?
Can your lordship hear me now?
Yes, I can. Thank you. Thank you.
May I proceed, my lords?
You may continue.
My lords, I was dealing with the Tweya judgment of this court and pointing to the facts in that case where there were 400 pages omitted from the record. The missing pages were filed only 2 days before the hearing. The application for condonation was filed the day before the hearing. The third and fourth respondents hadn't filed heads of argument, and the result was that the court was in no position to consider the prospects of success. And we submit that those facts differ fundamentally from the present. We respectfully draw attention to paragraph 35 of the judgment in that case, where the court said the following: It's at page 15 of the typed judgment. The court said, "There's no reason why the missing pages could not have been collated and lodged immediately upon the realization of the inadequacy of the record. That realization should have occurred when heads were prepared on behalf of the first and second appellants in early May, but certainly at the latest on the 17th of May, when the third and fourth appellants' legal practitioners came to that realization. Yet the missing portions were only lodged on 6 June 2016, a court day before the hearing." Now, in this instance, the steps which the court suggested in Tvea should have been taken were taken. There was an immediate application for leave to introduce the missing parts of the record, which were placed before the court. As I've stated, the respondent has not opposed this application for the admission of the fourth volume of the record. And we therefore respectfully ask for an order in terms of the notice of motion in that application. The appellant must tender the costs and does so, but on an unopposed basis, because the application is not opposed, with respect correctly not opposed. And so if that order is granted by your lordships, the effect is that the exhibits volume is before the court because it has been admitted in evidence before the court. And that brings me then to the second interlocutory which I must deal with, which I can deal with more briefly. In its heads of argument, the respondent took the point that the appeal had lapsed and that there is no application for reinstatement of the appeal. And that appears to be based on the fact that the exhibits bundle has not been separately certified by the registrar of the court or quo. And we respectfully submit, while the rules, of course, are there to be complied with, the rules exist for good reason, there could hardly be a more technical and non-material complaint than this complaint by the respondent. Firstly, the initial record was certified by the court or quo. Secondly, if the first application is granted, the exhibits volume is before the court. That was what was sought in that application. What Mr. Rube said was, I request that the exclusion of the exhibits record in question be condoned and that the attached record to this affidavit be admitted as part of the Supreme Court record of appeal. So if the court grants that application, the record will be part, that volume will be part of the record before your lordships. It's common cause that that volume does constitute the record of the exhibits that were before the court or quo. That's alleged and not disputed, so it's the correct record. And further, it's also common cause that the respondent suffers no prejudice from the lack of a certificate by the registrar of the court or quo in respect of this specific volume. I emphasize, my lords, that if the first application is granted, the exhibits bundle, which was attached to the affidavit of Mr. Nube, is filed and is before this court as part of the record in terms of an order which will then have been made by this court. And to the extent that there's a defect in the absence of a further certificate by the registrar of the court or quo, the applicant says the following in the application for condonation at paragraph 10. He says, I respectfully submit that in the circumstances, the interests of justice favor the condonation of this oversight, and he requests that the appeal be reinstated to the extent necessary. So to the extent that this appeal is not properly before the court because that exhibits volume has not been separately certified, we submit that that should be condoned. It is the record, it's common cause that it's the record, and it will have been admitted by this court. And we ask that it be that a reinstatement be granted to the extent that that is necessary. I want to say immediately that this matter could have been handled better and should have been handled better, but I submit that the oversight is not such that the court should non-suit the appellant, and particularly in a case such as this, a case of such importance, a case with such far-reaching consequences, and a case where, with respect, the prospects of success are good. So this is not a case in which the oversight, in the words which this court repeatedly uses, of where the oversight is so glaring, flagrant, and inexplicable that condonation should be refused without the need to consider the merits of the appeal. We respectfully submit that the court will consider the merits of the appeal and then make its decision on the reinstatement to the extent necessary. We submit further that if the court is minded to reflect its displeasure of what has happened in the order which it makes, the appropriate remedy would be an order for costs, but not closing the door to the appellant in a case of this huge importance with reasonable prospects of success, when in truth, all of the material has been before this court since the 17th of February of this year. And so we ask with respect that the second application also be granted. My Lords, unless there are questions which your Lordships wish to address to me on those matters, I'd like to now proceed to the merits.
No. Thank you, Mr. Bundler. You may proceed to the merits.
As the court pleases. My Lords, I'm going to deal with 5 core issues, or make 5 core submissions in the course of my submissions on the merits. The first is that the respondent sues on the 2009 Memorandum of Understanding. That is its cause of action, is a 2009 Memorandum of Understanding. Second core submission is that in its own terms, the 2009 Memorandum of Understanding was to govern 2 years, 2009 to 10 and 2010 to 11. That's what the MOU says. Thirdly, that there are at least 7 statements in the record, in the exhibits, of the limited period of this agreement of 2009. One will find it, and I'll take your Lordships there in due course, one will find statements to that effect in the MOU itself, and in the letter from the Office of the Prime Minister, and in the 2010 implementation agreement. They all show 7 statements that the 2009 MOU was limited in period. It was limited for 2 years. The fourth submission I will make is that the 2012 agreement covered the same ground. As far as qualified teachers in remote areas are concerned, it is identical in the benefits it provides, and it is identical in the purpose of the benefit. It is a subsequent agreement covering exactly the same ground as the 2009 MOU. And then fifthly, we say that I'm going to make the submission that if the 2009 MOU had some sort of shadow afterlife after 2011, it was superseded by the 2012 agreement. I will submit that the 2012 agreement didn't intend to provide a second and identical benefit, which was in addition to the benefit which was provided under the 2009 MOU. And so I'll address the following issues. Firstly, the cause of action. Then I will address the terms of the 2009 MOU. Then I will deal with the 2012 agreement. So let me go then straight to the cause of action. The convenient place to start is by identifying the respondent's cause of action. One finds that in volume 1, at page 5, I beg your pardon, at page 2, volume 1, page 2, paragraph 5.1, the parties, together with the Namibian Public Workers Union, NAPWU, on 23 January 2009, entered into a memorandum of understanding in terms of which the parties agreed and endorsed that the matter of school principals and incentives for teachers submitted to the Office of the Prime Minister be finalized and implemented effective from 1 April 2009. And then secondly, 5.2, the aforesaid agreement was implemented by a collective agreement concluded between the parties on 10 November 2010. The parties agreed to implement the 2009 agreement. So what they were implementing was the 2009 MOU, not making a new separate agreement. It was an agreement about how to implement the 2009 agreement. The parties agreed to implement the 2009 agreement in respect of the recruitment and retention incentive for qualified teachers. And then at page 5 of that volume, one finds the relief which the respondent sought. Plate 5, line 13, statement of relief claimed. Paragraph 1, an order declaring that the collective agreement dated 23 January 2009 is a valid existing agreement. Secondly, an order declaring that the collective agreement dated 23 January 2009 did not lapse on the implementation of the 2012 collective agreement. Thirdly, an order that the respondent pays qualified teachers in remote areas their recruitment and retention incentive as per the 2009 collective agreement read with the 2010 implementation collective agreement. And I emphasize, what I'm saying may seem quite trite, but what I underline because of the submissions I'm going to make in what follows is that what the respondents, the then plaintiffs, were seeking to do is to enforce the 2009 agreement. It's the 2009 agreement which is critical, and the 2010 agreement is relevant insofar as it deals with the implementation of the 2009 agreement, but it's the 2009 agreement which they wanted implemented. So that takes me then to the 2009 agreement as to what it provided. The first thing one notices I submit in the 2009 agreement is the period which it covers. And if one goes to the exhibits volume, page 16, it's exhibit B. Are your lordships with me?
Yes.
Thank you, Lords. Page 16, exhibit B, paragraph, this is the 2009 MOU, and paragraph 2 is the governing clause. What does it say? It says 2, agreements. The negotiating terms concluded negotiations for 2009/10 and 2010/11 financial years and agreed as follows. And then what follows are all the details of what they'd agreed, including the incentive allowance. I'll come to that. But I draw the court's attention to the fact that these were negotiations for those 2 financial years. That's what the MOU states in terms. Then if one goes to page 19 of that volume, at the top of the page, one sees, this is still part of the MOU, one sees the parties further agreed to investigate and finalize the following issues during the period of this agreement. So the parties acknowledged and knew that the period of the agreement was for a period. It wasn't an indefinite agreement or agreement forever. It was an agreement for a period. Thirdly, on that same page, a bit further down, paragraph towards the foot of the page, one will see paragraph 2.6.5, which deals with incentives for professionals. That's not teachers, it's professionals more generally, scarce skills, remote and hardship areas. And I draw the lordship's attention to the last paragraph on that page. The parties further agreed that an investigation be conducted regarding incentives of professionals with scarce skills and be finalized for implementation during the term of this agreement. In other words, this was not to be forever, it was during the term of the agreement. The parties knew there was a term. So we say the agreement, the MOU could not be clearer in this regard. This was an agreement which was not an agreement which was to run forever or indefinitely. It was an agreement to cover those 2 financial years, 2009-10 and 2010-11. If one then asks, what in the MOU did the government undertake to do with respect to incentives for teachers, one finds that at page 18, paragraph 2.5.1, and I'm going to come back to 2.5.1 shortly, so I do need to draw to your lordship's attention. 2.5.1, school principals and incentives for teachers. The parties agreed and endorsed that the matter of school principals and incentives for teachers submitted to the Office of the Prime Minister be finalized and implemented effective from 1 April 2009. That's the clause on which the respondent relies. As your lordship will have observed, at that stage, The MOU did not say what the incentives would be and how, to whom, and so on. The next step, so what one had in 2009 was an agreement for 2 years, and it was clear that the agreement as to the details of the incentives would have to be provided yet after discussion and negotiation. And that happened then was that took place. And the next step is in the process is the letter from the Office of the Prime Minister on the 11th of September 2009. And I draw your Lordship's attention to the fact that this is the next step after the MOU. The first thing that the letter from the Office of the Prime Minister does is it puts the flesh on the bones of the 2009 agreement by specifying what the incentive will be. And your Lordships will find that in Exhibit C, which commences at page 21. And I beg your pardon, Exhibit C, C1, which commences at page 24. And if I can take your Lordships there's a series of passages to which I wish to draw your Lordship's attention. The first thing to which I draw your Lordship's attention, page 24, is paragraph 1 of that letter from the Office of the Prime Minister. Your letter S811 dated 4 September 2008 and paragraph 2.5.1 of the Memorandum of Understanding signed between government and the unions. Now, members of the court will remember that's the one which says this will be addressed by the Office of the Prime Minister and finalized for implementation. Then that's what it's about. The letter then states.
One moment, Mr.
Judge Walker's running into problems. I can't hear you.
I beg your.
Judge Walker's running into problems. Can't hear you.
Oh dear. Is it?
I think it's a bandwidth problem.
Yeah.
Could Mr. Butler just say something?
Can your Lordship hear me now?
Yes, I can. Thank you.
Thank you, my Lord. May I proceed, my Lord?
Yes, thank you.
So, Exhibit C1, the letter from the Office of the Prime Minister, says this is a letter to deal with paragraph 2.5.1 of the MOU. And then in paragraph 2A, paragraph 2, he says, the office says, that the Prime Minister, on the recommendation of the Public Service Commission, has approved the introduction of a recruitment and retention incentive for qualified teachers. 2A, the purpose is intended to support the recruitment and retention of qualified teachers to rural areas. That's recruitment, in other words, getting them to apply for jobs, and retention, getting them to stay when they've been hired. 2B sets out the amount of the monthly incentive. In other words, what this letter did was it transformed the in-principle commitments of the 2009 MOU into a legally binding agreement and undertaking. Second, the agreement underlined the duration of the commitment. And one will find that on page 25 of the exhibits bundle. Paragraph D on page 25 says, headed duration. As the allowance is an incentive to support the recruitment and retention of qualified teachers to rural schools, the success or failure thereof needs to be evaluated on an annual basis with a complete review to take place by the end of the 2010/11 financial year. So that suggests that this is not a permanent arrangement. It's to be reviewed after 2 years. And then, to the extent that there could be any doubt about it, the first bullet point in that paragraph E, the Office of the Prime Minister states in terms, the incentive is not permanent in nature. It could not be clearer. And 3 lines down, it repeats that a complete review will be needed at the end of the validity of the current MOU. Well, in other words, that's another recognition that the MOU is limited in period. It doesn't run forever. And then it's restated, it's restated in those 2 points. So what we know is that this was not a permanent benefit. It was only to run till the end of the validity of the MOU. And we know from the reading of the MOU what its period was. It was to run for 2 years, it was to end at the end of the 2010-11 financial years. It seems not clear on the record, but it seems that the government delayed in implementing the incentive, which was promised on the 11th of September 2009, and the union then declared a dispute. That dispute resulted in the collective settlement agreement of 10 November 2010. That's Exhibit C at page 21. Now, by this time, by November 2010, the 2-year period was starting to draw to an end. 21 months had already passed. 18 months had passed of the 15 months. Sorry, let me start again. 15 months had passed of the 2-year MOU. And the agreement sets out how this was going to be dealt with. If one goes then to page 22, this is the 2010 agreement, which is Exhibit C. One sees apparent towards the middle of the page what they were talking about. It says, whereas the parties met and deliberated on the issues in dispute, namely A, the implementation of the memorandum of 2009, that's the 2-year agreement, and B, the wrongly categorized and omitted schools. Then they deliberate, and then it says the following. 1.1, under implementation, the GRN will implement, pay, the recruitment and retention incentives to qualified teachers for 15 months, 1 April 2009 to 31 June 2010, as a once-off payment before 20 October 2010. 1.2, the remaining 9 months, July 2010 to March 2011, recruitment and retention incentives will be implemented or paid on or before 20 June, subject to a proviso. Now, what are the remaining 9 months? That has only one meaning, namely that there were 15 months had passed and there were 9 months remaining of the MOU. 24 months, in other words, a 2-year agreement. It underlines that this is a 2-year agreement, or that the MOU is a 2-year agreement because 15 months have passed, and after 15 months have passed, there would only be 9 months remaining. The clearest possible indication that everybody knew and agreed that this was a 2-year agreement. Then what the parties recognized that the commitment was for a period of 2 years. Then in 1.3, in addition, the government stated that after the 2009 MOU had run out, after the remaining 9 months had passed, the government would continue to pay incentives to qualified teachers. It says, as from 1 April 2011, that's after the MOU has run out, incentives to qualified teachers will be incorporated into the ministry's budget 2011-2012 and be paid on a monthly basis. So we say the following is clear from this. We say that it was clear beyond doubt that the 2009 MOU would come to an end at the end of the 2010/11 financial year. And it is also clear that the government said it would continue thereafter to pay the monthly incentive from its normal processes. So the position is
Yes, the moment. If I just may ask, in terms of the paragraph 1.3,
yes,
read with the 1.1 and 1.2, what would the incentives refer to there? Which incentives do they refer to?
those, my lord, are the incentives which are referred to in the letter from the Office of the Prime Minister, dated 11 September 2009, and the incentives referred to in the 2009 MOU. Read together, it's an incentive for qualified teachers in remote areas.
Okay. Thank you.
Thank you. So what we submit is that the 2009 MOU plainly came to an end at the close of the 2010-11 financial year, but the government said it would continue paying. That couldn't be part of the 2009 MOU because the 2009 MOU would have expired by then, expired in March 2011. But as part of its normal budgetary processes, of course, if the government refused to continue paying as it had said in 1.3, the union might have had a cause of action based on that. But that's not their cause of action. Their cause of action isn't the 1.3 provision. Their cause of action is the 2009 Memorandum of Understanding, which lapsed in March 2011. So what happened then was that the government did continue to pay the incentive for qualified teachers after the lapse of the MOU. And then in 2012, two things happened. Firstly, one thing happened, but through one agreement. What happened was that the incentive which was being paid to qualified teachers in rural areas, remote areas, was broadened to include all public servants in remote areas. And it was incorporated in a new agreement. This change, was incorporated and reflected in a new agreement, the 2012 agreement, to which Nantu was one of the signatories. So what we have is the 2009 agreement, which ends March 2011. We have a continuation of that benefit by virtue of the undertaking given by the government in the 2010 settlement agreement. And then in 2012, the government has further negotiations with the unions, both Nantu and NAPU, and they reach agreement that a benefit, an incentive, call it what you will be paid to all public servants in remote areas and not just to qualified teachers. And that brings me to, I'll come in a moment to what the 2012 agreement provided. But if I go back to, where I started, I don't want to repeat myself about the 2009 agreement and what its term, but as I've pointed out, the 2009 agreement, there are 7 clear statements, if I can ask the court to note them. There are 7 clear statements in the documents before the court as to the fact that the 2009 agreement was not permanent, was not indefinite, and came to an end in March 2011. The first one is the governing clause of the MOU, and that's at page 16, para 2. I'm not going to go back there. The second one is the reference in the MOU again at page 19 on the top of the page to quote the period of this agreement, close quote. The third one is the reference in the MOU at paragraph 19, page 2.5.1, to quote the term of this agreement, close quote. The fourth one is the statement in the letter from the Office of the Prime Minister at page 25, paragraph D. The fifth one is the statement in the letter from the Office of the Prime Minister in paragraph 2E, first bullet. The sixth one is in that same paragraph, the third bullet. And the final one, to the extent, the seventh one, to the extent that there could ever have been any doubt, is the collective settlement agreement of 2010, which refers at paragraph 1.2 to the remaining 9 months of the incentive under the MOU. So we say that it could hardly be clearer that this was not a permanent benefit, which ended at the beginning of the end of the 2010-11 financial year. Now, all of those, in our heads of argument, we draw attention to all of those facts. None of that is answered in the heads of argument for the respondents. They don't explain how this could be an indefinite agreement, if the MOU, if in the light of all of those indicators. And that we understand why they don't address it, because with respect, there is no answer to it. There can be none. Of course, if the court didn't comply with the further statement in the 2010 agreement, paragraph 1.3, we'll continue paying the incentive. Then NANTU could have attempted to sue on that breach if government hadn't paid. But the government did continue to pay. And it paid until the 2012-15 agreement, it bound itself again. By the time of the 2012 agreement, the obligation under the 2009 MOU had long since expired. And with respect, it is an entirely opportunistic position for NANTU to adopt, to say that because in 2012, this benefit was extended to all public servants in remote areas, they are entitled to a double benefit, to the lapsed 2009 MOU benefit and to the expanded 2012 benefit. We say that the respondent attempts to suggest that they can rely in some way on the review by Stellenbosch University, which talked about which assessed the value of the benefits and made suggestions in that regard. But what Stellenbosch University said in its report, which was in 2014, can hardly be relevant to interpreting what the parties did in 2009 and in 2010. They weren't implementing the Stellenbosch recommendations because the Stellenbosch recommendations didn't exist. The Stellenbosch recommendations, you'll find the report is dated 27 August 2014. It's at page 48, line 32. So that brings me finally, my lords.
The Stellenbosch report, if I can just come in here, actually served to demonstrate why it was so important to provide a benefit for teachers in remote areas because of the gross disparity that you see in the way in which qualified teachers were not going to rural areas. So that if someone complained about an equal amount wasn't being spent on pupils in other areas, this would clearly be a case where Article 23 of the Constitution would apply, and the need for spending more on ensuring that qualified teachers go to remote areas to try and bring about some form of equality in education would be justified.
That is so, my lord. Very so. And that, of course, is what happened. By the time the Stellenbosch report came out, the 2012 agreement had been signed to extend the incentive and to apply it to other public servants. The Stellenbosch report also recommended that there should be an increase in the amount, suggested an amount that should be increased by. There's nothing on the papers to show that that's ever been taken up. But certainly one can't imply from the suggestion by Stellenbosch that there should be an increase. The decision 2 years earlier, a conclusion that 2 years earlier they decided to double it by giving a double benefit to the teachers compared with everybody else. So that takes me to the 2012 agreement, and we've made the submission. I'm not going to repeat it, that the 2009 MOU lapsed at the end of the 2010-11 financial year. But if we dealing with the 2012 agreement, we make the submission that if your lordships were to find that the 2009 MOU was somehow still in force in 2012, somehow it had an afterlife, a shadow life, we say that it was then superseded by the 2012 agreement, because the 2012 agreement dealt with the same matter and in the same terms. The starting point is to recognize that the 2009-10 and the 2012 agreements deal with the same matter in identical fashion as far as the incentive allowance for qualified teachers in remote areas is concerned. It's the same benefit, same amounts of money, the same areas are covered, and it's for the same purpose. The only difference is that the 2012 agreement extends the benefit now to all public service employees. The purpose of the benefits we submit is the same. It recognizes, each one of them recognizes that it involves hardship to work in these areas, that as a result, it's difficult to recruit people and to work in these areas, shown by the Stellenbosch report, and it's difficult when they've been recruited to retain them in employment. And so there's an incentive or an allowance necessary to encourage teachers to take up employment and to stay there. And that, as Justice Smuts has pointed out, is part of the guarantee of equality. The relevant provisions I've dealt with, perhaps I could just go there briefly to our heads of argument, paragraph 17. Paragraph 17 on page 6 of our heads of argument. And we say that we summarize in paragraph 17 the elements of the 2009-2010 scheme. 17.1, the purpose was introduction of a recruitment and retention incentive for qualified teachers at remote schools. 17.2, the incentive was intended to support the recruitment and retention of qualified teachers to rural schools. Thirdly, the incentive is an allowance. Can I ask your lordships to underline that word allowance, because I'm going to come back to it. The incentive is an allowance payable on a monthly basis. That's in the MOU. In the 2010 agreement, I beg your pardon, and the Prime Minister's letter. 17.4, the allowance, if I underline that again, is an incentive to support the recruitment and retention of qualified teachers to rural schools. And 17.5, the amount of the monthly incentive allowance was specified. Now, the 2012 agreement is a carbon copy of that as far as teachers are concerned. It's an allowance or an incentive for the same purpose to the same people in the same amount. The only difference is that that benefit is extended to other people as well. And you'll find that the clearest indication, if one then goes to the 2012 agreement, at page 28 of the papers, it's Exhibit D. At the foot of the page, paragraph of page 28, paragraph 2.3, there's the statement. This is now the 2012 agreement. It's headed Incentive for Remoteness and Hardship Areas, an introduction of an incentive allowance for staff members stated at duty stations qualified as remote and hardship areas according to the following categories. So the 2012 agreement is clear as to what it is. It is an incentive, and the incentive is provided by paying an incentive allowance. And if one then goes to the public service rules, which were enacted in order to give effect to this agreement, one finds that in Exhibit G1 at page 36. This is now again putting the flesh on the bones and saying how it's going to be done. And your lordships will find at page 36, part 2, remoteness allowance. And the purpose is stated in paragraph 1. A remoteness and hardship allowance is paid to a staff member stationed at a duty station in an area specified as remote in recognition of the hardship he or she endures as a result of the limited availability of basic services, amenities, and infrastructure. And if your lordships will then go over to the next page, page 37 of Exhibit G1, one finds at the foot of the page guiding principles. And here's the first guiding principle. The working 5.2.1. The working and living conditions of staff members at duty stations in remote areas are challenging, which tend to cause a certain degree of hardship. these challenges refer to the availability of various types of services. An incentive recognizes this and encourages staff members to go to and continue to serve in these areas. In other words, it encourages recruitment, encourages them to go there, and it encourages retention. It encourages them to continue to serve in those areas. Now, that is exactly what the purpose was of the 2009/10 agreement. It was an incentive allowance to enable recruitment and retention. It is exactly the same purpose. And so the result is that the two agreements, 29 and 2012, cover the same matter. They cover the same benefit, they provide the same benefit to the same people, except that the benefit is also extended to others. And that, with respect, is where the quo got it wrong. And that is where it was misled or misdirected. If your lordships will go to the judgment of the quo, it's in volume 3. It's volume 3, page 334. If your lordships will go to paragraph 68 on that page, this is what his lordship said about he's now talking about the 2012 allowance. He says, paragraph 68, it would appear to me that the purpose of the allowance was to compensate a staff member for the hardship she or he endures by being stationed at a remote duty station. The allowance was not aimed at enticing not enticed or incentivized the staff member to move and to stay in the remote area. He or she is already stationed there and is thus paid an allowance for the hardship he or she is enduring. Now, with respect, that's inconsistent with what is stated in the 2012 agreement itself and in the public service rule which was made, where it's made clear that it is to get people to go there, to make it possible to hire them, and to make it possible to keep them. And it uses the phrase to which I drew your lordship's attention, incentive allowance. Then paragraph 69, his lordship said, in my view, even the designation of the two benefits clearly and already indicates the differences. The one is an incentive and the other is an allowance. But with respect, my lord, that's not so, because the documents refer to it as an incentive allowance. The 2012 agreement doesn't distinguish between incentives and allowances. It says what we're providing is an incentive allowance. I've shown that to your lordships. And his lordship then goes on to the differences between the meanings of incentive and allowance. In paragraph 70, he says, in light of all these considerations and insofar as it might be necessary to make a finding, my finding is that the qualified teachers' incentives, that's 2009, was separate and distinct from the remoteness allowance payable to all staff members of the public services stationed in remote areas. That's 2012. But I've shown your lordships that with the greatest respect to his lordship, that can't be so, because it is defined, the 2012 allowance is defined as an incentive. It's designed as an incentive to get people to go there and to stay there. And it's defined as an incentive, referred to repeatedly as an incentive allowance. The word incentive is used repeatedly together with the word allowance. And so we make the submission that the distinction which our learned friends attempt to draw, and which his lordship in the quo adopted, that one was an incentive and the other is an allowance, is without any substance whatsoever. Then we then make, so that with respect takes away the very foundation of the basis of the finding of the quo, because it's premised on two separate things for two separate purposes. We then make submissions, my lord, as to the nature of collective labor agreements. We make the submission that it is in the nature of collective labor agreements that they are for a particular period, that they lapse at the end of that period. We see that all the time in all of the agreements, and one sees it in the 2012 agreement. The 2012 agreement is for 3 years. It says so. So secondly, we say that this conclusion of lapsing is unavoidable where the two agreements deal with the same matter. And we give your lordships an example. We say if that were not the case, an employee could say, I want the cumulative payment of what was promised under the old agreement and what is now promised in the new agreement. I want both of them because the old agreement still survives and I must get both.
Mr. Butler,
Yes, my lord.
on the issue of the nature of the labor collective agreement, could you refer us to some authority on that point?
My lord, no, I don't have authority, my lord. I'm saying this operates as what we see from the agreements themselves. That there's a 2012 agreement for a period, and there's a bigger pardon, a 2009 agreement for a period, and a 2012 agreement for a period. And can I explain why I say that, my lord? Can I just say our learned friends rely on a judgment of the Labour Court in South Africa, which says that the terms of a collective agreement are incorporated in the personal service of contract. That must be so. But
Yes.
it doesn't mean that it goes on forever. And let me explain to your lordship why I say that. Let's assume that agreement A in year 2009 says that an employee in category X will be paid $15,000 a month. That becomes part of his terms of employment. And let's assume that in 2012, there's agreement B, which says that an employee in that category will be paid $18,000 per month. The employee can't say, oh, well, now I can have the $15,000 under the old agreement plus the $18,000 under the new agreement. The one supersedes the other because it is a new agreement for a new period. And what happened in the old period isn't automatically transposed into the new period, at least. And I have only to make this limited submission, at least where they deal with the same matter.
Yes, but isn't that the nature of collective bargaining? That every few years or whatever, the unions and the employers get together to negotiate terms which would apply for the next period.
Yes, that's in the very nature of collective agreements. We know that's how it works. And we know that when you want to find out what the benefits are of an employee in 2018 or 2020, you don't go back to the agreement of 2005 and say what was promised then. You go to the current agreement and you see what is promised under the current agreement, and you get what is under the current agreement. You can't cherry pick and choose and say, I'll have the salary from this agreement plus the salary from that agreement plus the benefit from different agreements. It's in the nature of collective bargaining that periodic agreements are entered into for a specified period, as happened in this case. Because as your lordships will see, the 2012 agreement also is for a fixed period. It's for 3 financial years. And so we submit that collective agreements generally stipulate the period for which they're valid, that the 2009 and 2009 agreement did in this case, and the 2012. Even if the collective agreement didn't stipulate the period of validity, it would necessarily be superseded by the later agreement if it dealt with the same matter. An agreement, if 2 agreements, one after the other, which deal with the same matter, the latter agreement supersedes the prior agreement. That's just a matter of common sense. And so we say that it follows that the 2009 agreement can't have an afterlife, which enables employees forever and a day to insist on being paid what was promised under the 2009 agreement. If our learned friend's argument is correct, in 15 years' time, when other agreements have been entered, no matter what the other agreements say about new benefits, the teachers can still say, well, I want my 2009 benefit in 2020 and 2030 and 2040. We say that simply can't be so as because of what we know as to how collective agreements operate. We make the submission, we point out that our learned friends rely on the statement in the 2012 agreement that the parties agreed to the improvement of salaries and benefits for staff. And they say, therefore, that must mean that this benefit was improved. And therefore, you conclude from that this is an agreement to pay a double benefit. We respectfully submit that the claim is lacking in logic. But in any event, it's without foundation because the 2012 agreement did improve salaries and benefits for staff members. It extended an existing benefit to which a small number received, to a very large number, to all public servants. And if you look at, even if you take that clause in isolation, never mind the other improvements, just that clause in isolation is transparently an improvement in the benefits of public servant staff members. because the scope of the benefit is increased, is greatly extended. So to come to a close, my lords, we make the submission that I'll come back to the submissions I made in opening on the questions of the merits. Firstly, that the respondent sued on the 2009 MOU. Secondly, the 2009 MOU was limited to 2 years, and there are 7 statements which show that, which I've shown your lordships. Thirdly, or fourthly, in any event, the 2012 agreement covered the same ground. It's identical as to the benefits to be provided to qualified teachers in remote areas, and the purpose of the benefit is not a different benefit, it's the same benefit. And so we say that even if the 2009 MOU did have some sort of shadow afterlife, after March 2011, it was superseded by the new collective agreement in 2012, and the 2012 new agreement didn't provide a second identical benefit in addition to what was being provided. It simply confirmed and repeated the 2009 benefit and extended it to all public servants in rural areas. So we respectfully submit that the appeal should be upheld with costs. And we ask that the order of the court or quo should be set aside and replaced with an order that the claim is dismissed. Those are our submissions, my lord.
Thank you.
I think we want to give him a chance to speak to his junior if there's anything. And maybe, should we just take a 5-minute break?
Up to half. Can we take up to half? 11.
Do you want we can 5 minutes, isn't it? Yeah. Okay.
Mr. Bartlett,
My lord.
we'll take a, because it's 4:15 now, we'll take a break until 11:30.
As the court
To give you an opportunity to speak to your junior if there's anything that you want to consult.
I'm very grateful, my lord. Thank you.
Thank you. The court will adjourn until 11:30.
Yeah, but you know, the problem there is they want that. But can you hear when one speaks? You can see when they are spelling. Can you see what?
Yeah, you should just tell them to get back. Was it the no? Must I make it bigger already?
What is it?
The three.
I'll not keep on equally. So once, because I'm sharing now, once I take off that share, it should be fine.
Oh, it should be fine. Okay. Make the melody. You know what? We start eating the one on the
I mean,
Council?
Yeah.
Can everyone hear me?
I can hear you.
Yes. Just note that they are calling the judges, so please be ready.
Thank you.
Thank you.
Thank you. Mr. McWilliam?
Thank you very much, my lords.
Thank you.
I hope all three of you can hear me.
Okay. Yes, you may proceed, sir.
Thank you very much, my lords. My lords, if I could deal with the preliminary issues.
I don't know what's the position, whether you want to address us on that condonation
You may
application.
proceed, sir.
I think I still have the same problem previously. Experienced.
Whether you want to address us on that condonation application.
Yes.
Yes.
Okay. Thank you.
May I proceed, and can all three of you hear me?
Yes. Yes.
Thank you. If I could just deal with the condonation issue first. There are, in fact, 3 applications for condonation by the appellant. And there's an application for reinstatement as well. That was brought 2 days ago. So there are 4 interlocutory applications before you. You will have seen that within a day we filed our opposing affidavit in the reinstatement application. We filed it yesterday. And what my instructing attorney did is he set out, in essence, the fact that there have been a litany of breaches of the court's rules by the appellant. Now, having said that, you've seen from the affidavit, we don't suggest that if condonation is granted or reinstatement is ordered, that we will have been prejudiced, save for the question of costs. Equally,
I'm saying correctly. What was it? The host muted everyone. The host muted everyone.
Hey, we're just having some bandwidth problems here, apparently.
Lord, could I suggest that I should also disconnect my video while my learned friend is addressing the court? That may also reduce the strain on the bandwidth. So if with no disrespect to the court, and to my learned friend, I suggest I just stop my video. That might help.
Yeah, and we can call on you if there's any need. And
Yes, I'll be listening.
thank you.
Thank you.
is that better, my lords?
Just one moment.
Yeah, look, Badland has gone now.
Yes,
fine. Yeah.
You may proceed.
Thank you very much. So what I had indicated is that my instructing attorney had filed his opposing affidavit, and he'd set out the litany of breaches of the court's rules by the appellant, but we concede that if condonation is granted and the appeal is reinstated, we can't say that we've been prejudiced, save for the question of costs, and Mr. Badlander has now tendered the costs, so that means that in the result, we leave the decision insofar as those 3 applications for condonation and the application for reinstatement in the hands of the court. I just want to canvass one issue that arose during the course of Mr. Badlander's address, and that was he dealt with the cost implications of this application, and he quoted from the Stellenbosch Review. Now, that's not an issue that's been addressed in the founding papers in any of the 4 applications that have been filed, and so we haven't had an opportunity to deal with it. I would just point out that plainly, it is a matter of considerable importance to the teachers as well. And just to put that into context, the paragraph from the Stellenbosch Review, which Mr. Badlander quoted, was at page 83, which that goes on to read that, as I say, I can't address the actual figures and whether they're correct or inaccurate, but it goes on to record that due to inflation, it's page 83, the first bullet point of the exhibits bundle, due to inflation, the real value of the incentives has declined by about 30% since they were introduced in 2009. The spending on incentives constitutes only about 0.7% of the budget personnel spending in the 2014-2015 budget on the two programs of primary education and secondary education. And plainly, my client's submission, the fact that the government hasn't paid what we believe it should pay is not something which should be held against our clients. It's 5 years now they've been waiting for, they say, what they are entitled to. And the fact that interest may have gone up and the amount might have risen, that's not something which can be laid at the door of my clients. So against that, I plan to turn on to the merits unless there's anything further that the court wishes to raise with you. Now, if I could just start my address by dealing with the court or quo's judgment. Now, this court will have appreciated that a number of important points were made by the court or quo, and we will argue and suggest that they're unacceptable. Sorry, they're really not controversial, and all of them are sound. And we obviously subscribe to the judgment of the court or quo. But if I could just pause on a specific issue for the moment, that's the question of the differences in the incentive and the allowance. Now, I will take you to the specific agreements and the specific circumstances which are relevant when the court comes to consider those. And I refer the court specifically to the judgment of the court or quo. It's volume 3, page 332, para 65, to page 334, para 71. And I won't take you to them, but can I emphasize that they plainly different and have a different purpose, and to the extent that there is a document which the government issues after the conclusion of the agreements, after the conclusion of the 2015 agreement, in which it seeks to place an interpretation on what it thinks it agreed to, that statement is entirely inadmissible and has no evidential value. And that's specifically the reference which my learned friend placed heavy emphasis on, and I'll deal with in due course in more detail, but it's the rule, the service benefit rule, which you find at page 36, Exhibit G1. But I'm going to come back to it, but I want to emphasize that that document cannot serve as material to justify what the government is now attempting to argue in circumstances where it post-dates the actual agreement, and it happens to be an interpretation which the government may have placed, and I'll show you other parts of it which are supportive of my client's case, but because there is an interpretation placed by the government after the event on an agreement, that interpretation has no weight and carries no weight, or should carry no weight before this court. The second, my apologies. The second issue that the court or quo rightly emphasized, and we subscribe to, and that is that the resolution of the dispute before that court, as before this court, is dependent upon the interpretation of the written agreements. And as I shall show you, and as we've dealt with in the heads, there are in fact 5 of them. In other words, there are 5 documents which make up in the first instance, there are 3 that make up the 2009 2010 agreement, and there are 2 which make up the 2012/2015 agreement. And it's been instructive to listen to my learned friend having in his heads conceded that in truth there was a single agreement relating to the incentive, being the 2009-2010 agreement, in argument to attempt to move away from that concession, which is plainly correctly made in his heads, to try and distinguish the memorandum of understanding which was concluded in 2009, and elevate it to an overarching agreement, which he seeks to rely on without reference to, in my respectful submission, the circular that the government put out, the letter from the Prime Minister's office, together with the 2010 collective agreement. And where the court or quo made that provision is in volume 3, page 321, para 20, where, as we say, he correctly concluded that the outcome of this case is dependent upon the interpretation of the written agreements. The third point, which we want to emphasize, is that an important consideration taken into account by that court is the fact that payment of the incentive became a condition of the employment contracts of those qualified teachers who were employed at the remote schools. Now, that paragraph or that reference you find in volume 3, page 326 to 7, paras 42 and 43, and at page 334, para 72. Now, that is a fundamental proposition which, with respect, has not been answered in our learned friend's heads or in his oral argument. He talks about oral agreement, collective agreements and their effect, but provides no authority. Now, with respect, if one has regard to the judgment of the court below, as well as the authorities we quote in our heads, there's ample authority to indicate that in a situation exactly such as this, the incentive became a condition of the employment contracts of the teachers in question. And there's no suggestion in our view, our submission, that you can construe the agreements any differently. They were, that provision, that incentive, undoubtedly became a term or a condition of the employment contracts. And as such, it had a life which extended beyond the 2009 agreement. And the law with respect to that effect is clear to that effect. Then the fourth point is that the court below concluded the obligation to pay the incentive had not lapsed. And that you find at page 336, para 77. And what I'm going to show you in a moment is that the government's own witness, who it called, disavowed any reliance on this question of lapsing. This question of lapsing is a legal argument that's generated long after the event, which with respect was never an issue in the proceedings in which the court below, not the court below, which the arbitrator had to deal with. So we say with respect that that's a very belated attempt, an argument by the government. And in fact, we would argue it doesn't do the government any good by trying to rely or resuscitate points which not only are bad, but which their own witness didn't rely upon. Then the fifth point that we want to make is that the 2009, sorry, the fourth point we want to make, which the court or quo made, was that the 2009-2010 agreement had not been amended by the 2012-2015 agreement. So you find that dealt with at page 336, para 78 to 339, para 85. And we once again suggest or argue that the reasoning of the court or quo cannot be faulted. So as you've gathered, we support the reasoning of the court or quo as articulated in its judgment, and we have not heard any argument yet which we believe should give rise to this court overruling that decision. Then to turn to a different issue, and that's our heads of argument. In our heads of argument, we've carefully analyzed the 5 documents making up the 2009-2010 agreement and the 2012-2015 agreement. I'm going to take you to those agreements in a moment. We've also analyzed the remaining documents, which the appellant relies on as part of what he refers to, it refers to as the context. And we will show, with respect to have argued and will continue in oral argument to show that the context does anything other than support the construction which the first respondent places on the agreements. Now, before I turn to those written agreements, I think what we should look at, respect, if I may, is to take you to volume 1, because what we saw from volume 1 in the course of my learned friend's address was a reference to only portions of what the dispute was encompassed when the matter was dealt with in the applicant's summary of dispute. You find that at page 2. And what my learned friend quoted was from paragraph 5, and he quoted paragraph 5.1, which I don't need to read. Again, that is a reference to, can I call it the MOU, the 2009 MOU. But what he says in 5.2, what the applicants say in 5.2, is the force agreement was implemented by a collective agreement concluded between the parties on 10 November 2010. Now, you cannot view the memorandum of understanding separately from and independently of the collective agreement. Up until the time when the collective agreement was concluded, it hadn't been paid. When I say it hadn't been paid, the incentive had not been paid. Not only that, but I think it's very important, as I'll show you in the evidence in a moment, it's very important to appreciate that C1, so that's the exhibit, that's the Prime Minister's letter of September 2009. C1 is the document which, pursuant to the public service rules and the Act, implemented, as it were, it gave substance to the terms of the incentive. In other words, to the extent that it's argued in our learned friends' heads that the incentive didn't have an amount fixed or a categories fixed, it is that document which the government specifically issued in order to do that, and that was accepted. Those terms set out therein were accepted by my clients. So in that situation, the argument to suggest that the MOU is really without any substance is our respectful submission, just inappropriate. Not only that, but as I shall show you in a moment, it's not in dispute on the evidence that that was in fact the mechanism which was utilized by the government to implement the incentive. So in paragraph 5.2, as I've indicated, they deal with the MOU, with the collective agreement. In paragraph 5.3, they deal with the purpose. In paragraph 5.4, they then deal with the agreement of November 2012, and then they deal with the addendum in paragraph 5.5, and they deal with the various issues in 5.6 and 5.7 through to 5.8. And so it goes on all the way through to 5.13, where it says the qualified teachers effective 1 March 2016 no longer received the 2009 incentive, as it is alleged the government has elapsed. And they, at that time, they then received the 2012 hardship allowance. Now, there is nothing in that summary, in that document, which can be regarded with any, in my respectful submission, which can be regarded as excluding the documents which gave rise and happened after the 2009 Memorandum of Understanding, that you don't read the documents as a whole, all three documents together, which made up a single collective agreement. So we don't, we say when we have reference to the actual nature of the dispute and how it was formulated, the argument, which is really the fundamental argument of my learned friend, doesn't have any substance. But not only that, if you turn to page 5 in volume 1, and you read the statement of the relief claim, you'll see there are 5, in fact 6 paragraphs, which are all sought. And with respect, there's nothing controversial about that. One is an order declaring the collective agreement dated the 23rd of January 2019, a valid existing agreement. 2, an order declaring the collective agreement dated 23 January did not lapse on the implementation of the 2012 collective agreement. 3, an order that the respondent pays qualified teachers in remote areas their incentive. 4, that the back pay issue be dealt with. Now, it's true that it simply refers to the agreement of 23 January 2009, but all that is a reference to the Memorandum of Understanding, which gave rise to the incentive. There was, and never understood at the time, to be any attempt by my clients to restrict the relief which they seek and the issues which were in dispute to exclusively that agreement. And not only that, but when you have a look at the evidence that was led, there's not the slightest suggestion with respect that issue can, as argued by a learned friend, was ever an issue as it was understood when the parties argued the matter and did the evidence before the arbitrator. Now, it was Mr. Hein Gura, the first respondent Secretary General, who gave evidence on behalf of the first respondent, and Ms. Haipinga, the Deputy Permanent Secretary responsible for the Department of Public Service Management in the Prime Minister's Office, who gave evidence on the part of the government. Now, insofar as Ms. Haipinga is concerned, it is quite clear from the record that apart from what was written in the documents, in the exhibit bundle, she had no personal knowledge of any relevant fact and could not give any admissible evidence in that regard. Now, there are limited aspects of the evidence, and specifically hers, which I just want to touch on, but if I could deal with them in order. First of all, if I could deal with the status of Exhibit C1, that's Exhibit B, page 24. Now, it's the letter from the Office of the Prime Minister dated 11 September 2009. Now, if you have reference to Mr. Haingura's evidence, he deals with this issue in volume 2 at page 189. And he deals with it at page 189. His evidence is not always as clear as one would like, but he deals with page 189 from line 9 through to 190, line 13. And if you turn over the page, so at 189, he's dealing with C1. Over the page at 190, he says, we engaged and we agreed in principle as how we forwarded to the Office of the Prime Minister for endorsement or implementation. Unfortunately, the memorandum of the collective agreement, the memorandum of understanding was entered into in 2009, does not spell out what we discussed at the ministerial level, but they always had two teams who went, to a certain extent, even they went to Botswana, what Botswana doing. That is how we determine now, in 3 categories, depending on that specific environment. Those are the 3 categories you find in C1, as we indicated, the issue of the infrastructure at those particular areas. Now, he deals with that again at page 200. And he says the purpose of the circular, page 200, line 16. The purpose of the circular. Sorry, this is now, my apologies, I've gone ahead of myself. This is now Ms. Haipinga. So this is the appellant's own representative that I'm quoting from. Her evidence starts at page 196, and she deals with it at page 200, and she says the circular at page 200, line 18. The circular responds to the agreement to implement. So the circular set out the terms and the parameters for implementing the incentives. And then she goes on to say, insofar as its purpose is concerned, she says at page 207, says, being put to, okay, it is difficult to attract qualified teachers to remote and hardship areas. Correct. Qualified professionals, is difficult to attract them to very remote areas. She says she doesn't have the statistics, and then questions put again, the foot of the page. Let us talk about 2009. It was difficult in 2009, correct. That is why you gave them the incentive to recruit them and to retain them in remote areas, correct. It says, yes, that was the submission of the ministry. It says, no, that was the agreement that was concluded, isn't it? It says, okay, let us talk about submission. It is an agreement. So it did not apply to unqualified teachers. It says, yes. It also did not apply to a driver, a handyman, a cleaner. Yes. Because the intention of the incentive was to attract qualified teachers, correct? And she says, yes. I also, my apologies, I just omitted, I'd gone too quickly. 189. Yes, at page, yes. And then, sorry, I've gone ahead of myself, my apologies. If I could just ask you to go back to page 190, where Mr. Haingura was dealing with the, this is in volume 2, where Mr. Haingura was dealing with the categories and the letter C1. It's at line 9 that I just want to take you to. So he discussed how the 3 categories had been assessed by the government, and then deal with that at line 9 through to 10. And then insofar as the amounts are concerned, he says at page 191, line 19, he says, we just discussed this particular issues and presented to us. We looked at them and we just said, it is fine. It's reasonable from the beginning. The number of the amount at the present moment, when this thing we agreed upon, was not an issue of dispute, but the number is little and so on. We did not dispute the amount or the issue of the amount. So for my learned friend with respect to argue that it's a live issue at this late stage in these proceedings to suggest that the MOU is enforceable, as he does in the heads, because the amount and the details aren't specified, just is contrary to the evidence that was actually led. Now, no evidence was led by Ms. Hypinga to challenge that. In fact, she says, as I've given you the reference at page 200, line 18 to 20, that it set out the terms and the parameters for implementing the incentive. And I've dealt with the purpose of the incentive. And then if you could turn to page 226. She specifically asked in cross-examination whether this agreement lapsed. And it starts at page 226, line 6. Okay, you were here. Then you remember that one of the defined issues is that the conditions of the 2012 agreement has been complied with and that it has lapsed. You remember something like that? She says, I do not remember that word lapse from our side for the applicant. And then we determined the issues. How was the agreement complied with? The 2009 agreement complied with. How did it come to lapse? And when did it come to lapse? And she says, as I've indicated, I've not used the word lapsing. From our perspective, we just harmonize.
But what is the value of all this?
Well, with respect, what it shows is to the extent that my learned friend wishes to rely. So the value is limited, but to the extent that my learned friend wishes to rely on a definition, a narrow definition of the issues, which are served before the arbitrator, that narrow definition is inaccurate, both with reference to the issues as articulated, as well as with reference to the evidence that was given. That's the purpose. That's why I'm going there. But quite correctly, you've seen, as I've already submitted, we say, just like the court of quo, that it's the agreements, and the agreements in their totality, which will determine what the outcome of this case is.
Clearly, that's why I was asking.
And I take those issues no further than that. And against that issue, then, if I can ask you to turn to the agreements. Now, the first agreement is inevitably the MOU. And we view it, as you've seen from our heads, we view this agreement very differently to the manner in which our learned friend does. And the essence of the argument, as we understand it, a fundamental proposition that's been argued by our learned friend is that the MOU had a finite lifespan, and at the end of April 2011, it came to an end. Now, that simply, we say, is neither borne out by the facts, nor is it borne out by the terms of the agreement, nor does it, is it a valid argument taken, one takes the agreement on its terms. 2.1 at page 16 is headed salary increments. And what it says, under paragraph 2, under the heading, the negotiating teams concluded negotiations for 2009-2010 and 2010-2011 and agreed as follows. Now, what my learned friend says is that implies that at the end of 31st of March 2011, the agreement came to an end. Now, that must mean that, therefore, on that assumption, the salary increments also came to an end. Now, that's just a preposterous suggestion we submit. There's not the slightest suggestion that in 2.1, the salary increments of 28%, which were paid in over 2 financial years, ended at the end of 31 March 2011. You could never, no union would ever live with that interpretation, and no government would suggest that come the 1st of April 2011, they could have put a line through the salary increments which were being paid pursuant to this agreement. Quite plainly, what happened is these are the increments that were negotiated for this period, and until those increments are ended, they continue to be paid. That's what happened, and there isn't, with respect in our submission, any basis to suggest that in that situation, the increments fell away. And equally, that would apply to the incentives. Now, if you go to paragraph 2.5.1 on page 18, being the operative paragraph, It says in terms, the parties agreed and endorsed that the matter school principles and incentives for teachers submitted to the Office of the Prime Minister be finalized and implemented effective from 1st of April 2009. There's no date from which it's going to come to an end. That's the date from which it's to be implemented. And if you then turn over to page 19, my learned friend places emphasis on the use of the words during the period of this agreement at the top of the page, and during the term of this agreement towards the end of that page. But all that is dealing with is issues which needed to be finalized during the course of that agreement. It's no suggestion, in our respective submission, viewed as a whole, that you can suggest that at the end of 31 March 2011, all of these incentives, salary increments, and other issues that are being addressed fell away. That simply wouldn't be a business-like interpretation of the agreement, and we say, with respect, that simply can't be what was ever intended, and it wasn't what was intended. Now, if you then turn to the letter from the Office of the Prime Minister, what you will see is in the introduction, it's headed the introduction of a recruitment and retention incentive. Qualified teachers.
Sorry, it's on what page? Sorry, it's on what page?
I'm at page 24. I'm at page 24. I'm dealing with the letter from the Office of the Prime Minister, and it's this letter which gave the meat, if I can call it that, it gave the details to the incentive, which had been negotiated and agreed to in the Memorandum of Understanding. And it governs, the letter is headed that it governs the introduction of a recruitment and retention incentive. In paragraph 1, it specifically cross-references back to paragraph 2.5.1 of the MOU, that's at page 18. And then in paragraph 2, it specifically refers to and invokes Section 5(2)(e) of the Public Service Act, 13 of 1995. We've given you that reference in our heads, and we've given you in our bundle of authorities cross-reference to that specific section. And it's quite plain that what the Prime Minister did is what he was authorized and entitled to do. He effectively made the incentive, he turned the incentive from an undertaking into a binding obligation. And we say with respect that there's no ways you can interpret this document in any other way. Now, its purpose in unequivocal terms is stated to be that the incentive is intended to support the recruitment and retention of qualified teachers to rural schools. It's an incentive for qualified teachers to go to teach in the rural areas, and specifically areas where there's a paucity of qualified teachers. And you will see that in the preceding paragraph, it's to come into effect from 1st of April 2009, and there's no date upon which it terminates. It simply says that it's with effect from 1 April 2009. Now, paragraph B deals with the monetary amounts. Paragraph C says it's the scope of the application. Staff members in the teaching job category of the schools listed in the attached schedule will receive the allowance mentioned here on a monthly basis as part of their monthly income. It's not for 12 months or 24 months, it's as part of their monthly income. The allowance
yes, but the duration sets out there.
I'm getting it.
Yes.
So, and it says at the top of the page, the allowance forms part of a comprehensive package with the expressed aim of encouraging qualified teachers to go to schools in the rural areas, and in so doing, improve the standard of education in such areas to the national level. That's its expressly stated purpose by the Prime Minister, the Office of the Prime Minister. Now, that with respect is something very different from, as I shall show you in a moment, the allowance. Now, let's deal with the duration, because there are two issues. The duration is effectively dealt with in two paragraphs, D and E. And if I can deal with D, as the allowance is an incentive to support the recruitment and retention of qualified teachers to rural schools, the successful failure there needs to be evaluated on an annual basis with a complete review to take place by the end of the 2010-2011 financial year. Now, that was what was intended, that there would be a review. Now, if the government doesn't undertake that review, it cannot be suggested that the incentive has come to an end. If the government is of the opinion, for example, that the incentive is an exceptionally good provision and says, don't worry, we're not going to go ahead with the review, it could not be suggested that that is something which the teachers must now do without. Because quite plainly, it's a review and nothing more than that. And the review plainly is going to be undertaken by the government. And it goes on to say, the maintenance review, it's proposed that the Ministry of Education maintains a robust statistical record which will confirm either success or failure of the incentive. In other words, the government is setting up for itself a mechanism to ensure or to measure the success or failure of the incentive. And what I shall show you in a moment is not only do they do that, but in fact, they do measure it. And in fact, they appoint the Stellenbosch University to undertake the review, and its results are positive. So just before the first bullet point, it says the reason why the statistics need to be kept for all schools is the need to manage the system in an integrated manner. As the consistency of teacher availability, that's the issue, the consistency of teacher availability across the whole sector is in essence the bigger purpose of the strategy. So when you read all of those provisions, it's quite plain what the purpose is. It's to attract and retain qualified teachers in rural schools. Now, the first bullet point, which my learned friend placed so much emphasis on, to say the incentive is not permanent in nature. Now, we're not suggesting that the incentive is not something which, as you find in the documents which we take you to, was going to simply last up until 2015 or 2018, unless there was if there was a review, and that review found that the incentive hadn't been working, it wouldn't be a permanent thing. The staff could not come and say, a qualified teacher could not come and say, we've got an incentive, the government has now reviewed it, and arising out of that review, the government has decided, or it's been shown, the incentive has no value. Therefore, whatever the government may do by virtue of its review, we, the teacher, insist that we be paid our incentive, irrespective of whether it turned out the incentive shouldn't be paid. So all that's indicating, it's not permanent in nature. It's not a permanent benefit because it's subject to a review. But absent a review, there's no suggestion that this incentive came to an end. Or, as with any other collective agreement, absent agreement in due course to terminate the incentive, signed agreement, which both parties agreed, that would also be another way which the incentive could be lawfully ended. But there's nothing here with respect beyond the question of review, which is supportive of the proposition that the incentive ended at the end of the agreement, because what the third bullet point says is a complete review will be needed at the end of the validity of the current MOU. So all it's saying is come the end of March, you need to have a complete review. We, the government, will propose that there will be a review. Now things move on from there. If the government doesn't do its review and it keeps paying the incentive beyond that date, it hardly lies in the government's mouth to argue that the incentive has in fact terminated, because there isn't any mechanism contained in this agreement which terminates that incentive. But if there was any doubt with respect to that interpretation, that doubt is put to an end by the collective agreement. And that you find at page 27. And what you find in paragraph 2 says, the parties agreed to the improvement of salaries. My apologies, I've gone to the wrong page. It's always disconcerting when you're reading something which is saying something you don't expect it to be saying. I should have been at page 21, my apologies. So I'm at page 21 of the exhibits bundle, and this is the collective settlement agreement. And the first point I point out, only NANTU, only the first respondent is party to it. The other union has fallen away. Why? Because this agreement affects only NANTU's members and specifically only qualified teachers. And at the bottom, it says implementation of the recruitment and retention incentives for qualified teachers. And then it cross-references back to the memorandum of understanding. Now, what we see, and my learned friend alluded to it, but what we also place emphasis on is in the middle of page 22, the fourth whereas. Whereas the parties met and deliberated on the issues in dispute, namely, A, the implementation of the memorandum of 2009. So there's no suggestion that all they're doing is anything other than implementing that agreement. That's what it says they intend to do, and that's what they do, because if you go to the operative portion of the agreement under the heading paragraph 1, it says implementation. Now, my learned friend sought to draw a line between paragraph 1.1 and 1.2 on the one hand and paragraph 1.3 on the other. Now, we say with respect, there is no basis upon which this court or any other court for that matter could do it. Because what is clear is that the implementation is being dealt with in 3 separate paragraphs. It's the implementation of the incentive. And what has happened is there was an undertaking by the government that that incentive would be implemented on the 1st of April 2009. And the government didn't pay. Arising out of which the government now has to back pay the incentive. So that's why you find in 1.1 and 1.2 separated paragraphs dealing with what amounts to back pay. Because in 1.1, it says the GRN will implement pay the recruitment retention incentives to qualified teachers for 15 months as a once-off payment before the 20th of October 2010. So if you turn to the next page of the agreement, you'll see it was signed on the 10th of November 2010. So it's saying on the 10th of November, it's saying we will pay you with effect from the 20th of October. We will have paid you the full 15 months which are due. But quite plainly, he doesn't have the money to continue paying it at that stage, and therefore 1.2 says the remaining 9 months. That's why it's reference to the remaining 9 months, because that's the amount which still has to be paid from July 2010 to March 2011, and that will be paid on or before the 20th of June. So the government is being relieved of the obligation to pay those 9 months on a monthly basis. It's saying we will pay it as a lump sum on the 20th of, on or before the 20th of June, provided the national budget is approved on a month before this date. So all that's dealing with are the first 24 months that payments weren't being made on a monthly basis as they should have been. Then in paragraph 1.3, that as from the 1st of April 2011, incentives to qualified teachers will be incorporated into the budget for 2011-2012 and be paid on a monthly basis. Now, this is not a separate self-standing obligation. This agreement relates specifically and expressly to the implementation of the memorandum of 2009, and insofar as 1.3 is concerned, that from 1st of April 2011, that will be paid on a monthly basis. No end date at all. No question of a review. No question of anything else being done. As a matter of law, as a matter of agreement, the government has formally undertaken that it will, from the 1st of April, on a monthly basis, pay the incentive. Now, to the extent that it could have been suggested in our respectful submission that that incentive ends, you have to look in the first instance to this agreement to see how that obligation to pay came to an end. And the only way in which it could have come to an end is now specified in paragraph 3. Because paragraph 3 is specific. In the second paragraph, it says in terms, no alteration, amendment, or addition will be valid unless such alteration, amendment, or addition has been induced in writing and mutually agreed by the parties thereto. So there has to be a written agreement signed by the parties which brought this incentive to an end in order for it to end. That's what the government agreed, and that, in this specific agreement, formed part of the issues in dispute between the parties from the very outset, as I've shown you. And it's been dealt with in my learned friend's heads. It's dealt with as part and parcel of the 2009-2010 agreement. And not only that, but while I'm at page 23 under the heading validity, The first paragraph says, this collective settlement agreement is a full and final agreement on the above issues and binding upon all the parties thereto. And the third paragraph reads, this agreement therefore settles the dispute on the implementation of the memorandum of understanding on this dispute. Agreement may be made in order of court. So when we talk about the implementation of the memorandum of understanding, it's quite plain from those two paragraphs that what this agreement did is it finally settled the implementation of the incentive, which was originally created in the memorandum of understanding. And there can be no suggestion with respect in the light of this agreement that the MOU, because it didn't have an amount agreed to or specific schools categorized, that is an agreement which wasn't enforceable, because the parties quite plainly understood it to be nothing other than a binding agreement which had to be implemented and which was implemented in terms of this agreement. Now, in our respectful submission, unless there is something in the 2012-2015 agreement which can be said to have novated or done away with this agreement, terminated it, that's in essence a complete answer to the case that my learned friends addressed to the court. But if I could turn to the incentive, if I could turn to the review, because the review is an important document for a number of reasons. Because to the extent that my learned friend relies on the fact that the MOU was subject to review, well, there was a review. The government did review it. And if one was to have regard to context, one must have regard to the fact that the government did, part of the context which was relevant when the 2012-2015 agreement is considered, is the fact that A, the government in the 2009-2010 agreement envisaged a review, but B, it did undertake that review. So that was material that was known to the parties at the time. And if you go to that review then, the question is, well, what was the outcome of the review? Because if you're going to say that this agreement was going to terminate on the event of a review, it must be implicit that that will only be if the review is adverse. If the review is positive, and the review says the incentive is a very good thing, and it should be continued, it can hardly be said that that review has had the effect of terminating the agreement, because that's the very condition which the government included, Prime Minister's office included, in its letter. So when we go to the review, you find in the first instance it's dated 27 August 2014. So there was no review that we're aware of, forms part of the papers, at any time before that. So the government continues paying the incentive and it then does the review. And if you turn from page 48 through to page 50, you'll see the top of the page, the second line, page 50. Historically in Namibia, the majority of unqualified teachers have been employed in rural schools. The majority of unqualified teachers have been employed in rural schools, creating a learning deficit there, which is further compounded by high rates of teacher turnover. The scarcity of skilled teachers in rural schools is a result of various factors. It deals with the factors. And then under the heading Financial Incentive Scheme. In response to these challenges, sourced it must be from the Minister of Education, the Minister of Education introduced a financial incentive scheme aimed at attracting and retaining qualified teachers in remote rural schools and so improving learning outcomes. There is exactly the purpose of the incentive. 4 lines further down, the incentives have been implemented since 2009. Since 2009, it's been implemented. This is now in 2014. To attract and retain qualified teachers in schools in such remote and rural areas. It was agreed at the time of its introduction that after a few years of the incentive, a critical review should be carried out into the effectiveness of the scheme and in particular the performance of pupils in those schools assisted by the incentive. And over the page, under the heading of the study, this report responds to the need for an assessment of the incentive system and was commissioned by UNICEF on behalf of the Namibian Ministry of Education. And then for the next 30-odd pages, it summarizes the work which was done by the review committee until you get to page 83. And right at the bottom, that page, under the heading Overall Conclusions, the authors say, the central question the study set out to answer relates to the effectiveness, efficiency, relevance, impact, and sustainability of the incentives. Over the page, impact and effectiveness of the incentives. The available evidence cannot conclusively show that the incentive had been the cause of improved distribution of qualified teachers, but it certainly suggests that they have had an impact. And so they deal with the efficiency of the incentives. They say, in terms of efficiency, if they did contribute, they must be quite efficient given their very low cost. And the relevance of the incentives, they say the incentives are clearly relevant in the sense that similar incentives are widely used in African countries to encourage teachers to take positions in remote schools. Then under incentives, Roman 1, sustainability of the incentives. They say the relatively small fiscal costs of incentives make them quite affordable within budgetary constraints. Even a substantial increase in the incentive would be fiscally sustainable, given that its small size means it can be diverted from general salary increases for teachers and other educational personnel without having too large an effect. Then under incentives, there's under the recommendations, my apologies, incentives 1, the system of financial incentives for qualified teachers teaching in remote schools should be retained in its current format. That over the page, it gets better. Page 85, under paragraph 3, in fact, they recommend incentive values should be increased substantially. So that's what the review, which the government itself recommends, which the government itself appointed, recommends. So to the extent that my learned friend argues, well, these qualified teachers are being unfairly dealt with because they want the incentive and the allowance, there's no basis for that. Because in fact, the very review which the government undertook to do recommended that incentive values should be increased substantially. In fact, then in the 5th line, it recommends that they be increased to $3,000 per month and so on. Then in paragraph 4, considering the Ministry of Education's intention to grow mainly the qualified part of its teacher corps, it is not recommended that financial incentives be extended to non-qualified teachers, despite the valuable contribution many of them make to rural schools. Now, with respect, it's quite plain then that there was a separate, distinct and specific incentive that was created. It was subject to a review, and the review is positive. If one has regard to this review, being the document to which you're entitled to have regard, bearing in mind that it was specifically referred to in the MOU and the Prime Minister's letter as part of the background material, there is with respect no basis to suggest, we argue, that the incentive has or should have come to an end, or that anyone thought that it should be terminated. Now, what we know then, and I shall show you this in a moment, is in fact that the government continued to pay the incentive. Because if you have reference to the exhibits bundle, it's at page 106. What you find is that, and just for the benefit of the court, page 106 and 107 refer to one individual, 108 to 110 refer to a second individual, and 111 to 113 refer to a third individual. They deleted the names of the individual, but this is pay slips that were put up by the government as part of the arbitration. But if I can just, they're the same, I'm just going to take you to page 108, if I may, 108 to 110, because those are the 3 relevant dates that were put up. Because what you find at page 108 is that this individual, this is his pay slip for the 20th of March 2012. So this date, 20 March 2012, is already after the 31st of March 2011. 31st of March 2011 being the date when, on the balance argument, the incentive had already lapsed. So here we have this payslip payable on that date, and under the heading payments, the third item, you'll see incentive allowance, education, 1750. That's the incentive allowance that was paid for education for a qualified teacher on the 20th of March 2012. You turn over the page, you find another pay slip for the same teacher, and you'll find that date is the 20th of November 2015, my apologies. At page 109, the payday is 20 November 2015. Now, that date, November 2015, is after the 1st of April 2015. And why I emphasize that is because the 1st of April 2015 is when, on the appellant's argument, that's the date when, on the appellant's argument, the incentive terminated. What they say, with effect from the 1st of April 2015, when the allowance was introduced, the incentive had come to an end. But the government's own document shows that, in fact, on that date, and after that date, and this specific date is November 2015, at a time when the allowance had already been given recognition in the agreement, the incentive continued to be paid, and you'll see that under the heading Incentive Allowance Education 1750. And then what you find over the page is that what happens after in fact, the day it happened, the month it happened was February 2017. Now, this is after the allowance not only has been implemented, but it's effectively been back paid, or had to be back paid. All of a sudden, the annotation, the statement as to what that 1750 is for is now different. It's now specifically reflected as being a remoteness allowance aid.
Yes.
Now,
May I proceed?
I could ask you to turn back then to page 27. You'll find this is the 2012 agreement, collective agreement from 2012. This is the agreement which introduces the allowance. So if I could once again just pause at the paragraph 2 headed agreements and emphasize the parties agreed to the improvement of salaries and benefits for staff members as follows. Now, that with respect is an important paragraph. It's not doing away with anything. It's not purporting to do away with anything. It's simply recording the agreement on the improvement of salaries and benefits for staff members. In its express terms, therefore, it has got nothing to do with taking away an incentive, taking away any benefit. It's simply got to do with an improvement on the situation as it existed at that time. And then at 2.1, the salary adjustment. A general salary adjustment of 8% is granted for all staff members with effect for 1 April. And plainly, that must be a salary adjustment on what was being paid on the day before, or in March 2012. And not only that, but you'll see this agreement relates to all government employees, both the Teachers Union and the Namibian Public Workers Union. Both unions are negotiating this agreement. They don't deal with, and don't purport to deal with the Teachers Union separately, and they don't purport, it doesn't stay, it does away with anything. In fact, the positive statements are that it relates to the improvement. In that situation, we say with respect, you can't read this agreement as terminating an incentive which isn't even referred to, as terminating an agreement which the parties agreed would only be terminated in writing, could only be terminated or amended in writing. It simply doesn't match that formulation.
It doesn't terminate, possibly, but may supersede that.
Well, you've got to look to see whether that's what it says it does. To what extent could it be said that this agreement supersedes, harmonizes, takes away, whichever language you want to use? Where do I find, with respect, I asked rhetorically, where does one find that indication? And the answer is you can't. It's not here. If it was, bear in mind that if one has regard to context, part of the context you have to have regard to is the 2009-2010 agreement. That would be part of the context. That's an existing obligation to pay. If you want to terminate it, then with respect, you would deal with it expressly. But you can't even find, not only is it not dealt with expressly, but you can't find an implied or a tacit termination, because the language is the exact opposite. It's doing something positive. It's not doing away with anything, it's simply doing something positive. And if you go on then to page 28, and you go to paragraph 2.3, this is where the allowance is introduced. And what it says in terms is an introduction of an incentive allowance. It doesn't say the extension of an incentive. It says we are introducing an incentive allowance for staff members stationed at duty stations. So it's all staff members, not a dispute. This allowance relates to all staff members. And it's those staff members who are at duty stations already. That's what it says. And those duty stations are classified as remote and hardship areas according to following categories with effect from 1st November 2012. So you've got, in its express terms, the introduction of a new incentive for all staff members who are already stationed at duty stations. That's what it says. Now, in our respectful submission, you can't find any implication, any tacit agreement that, in fact, this does away with an incentive which has been paid up until that date. But if there were any doubt in that regard, that doubt with respect is put to bed because the government continues to pay the incentive. It doesn't say, nowhere does the government say, well, now that this agreement is concluded on the 8th of November 2012, we're not going to pay the incentive. They continue to pay that incentive, as I've shown you from the pay slips. So this agreement, they couldn't have interpreted to have that meaning at that time, in my respectful submission. And when I say they couldn't, who knows what they did or didn't do, but it's not an inference which you can draw from this document. Now, if there was, in my respectful submission, any doubt with regard to those submissions, if you go to page 31, this is the addendum. Once again, it's both unions, it relates to all staff. And not only that, but under the heading preamble, it says, whereas the government of Namibia, the Namibian National Teachers Union, NANTU and NAPU, entered a collective agreement on November 8, 2012, that's at page 30, on the improvement of salaries and benefits of staff members. Not doing away with anything, it's on the improvement. And it could never be suggested if you're a qualified teacher that this document, or this agreement, if it took away your incentive and replaced it with an allowance, has improved your situation. That's simply not an inference you can draw from this document.
But there are other improvements like salary adjustments and that sort of thing.
That is so.
Housing and that.
Yes, that is so. So those improvements don't take away anything that already existed. Yes, they improve the salary. So what happened is, take, for example, salary. The 2009 MOU provides for increased salaries. It can't be suggested that this document took away those increases. Plainly it didn't. Because if you go back to the 2012 agreement, it says there's an 8% increase. It can only be an 8% increase on the salary as then existing, which was the salary then existing in terms of the 2009-2010 agreement. So it had to be with respect, and it was an improvement. And if the other benefits are improved, fair enough. And in fact, the obvious benefit, if you are a teacher, a qualified teacher in a remote area, the obvious improvement is that you are now getting an allowance in addition to your incentive. That's an improvement. That's what it means. That's what the words say. And the fact that the government has a different intention, a secret intention that doesn't express, is neither here nor there. And if you go on to read the second paragraph, whereas the said agreement included clause 2.3, that's at page 28, providing for a remoteness and hardship allowance. In other words, by definition, that must have been one of the benefits that are being improved. And whereas the parties convened in order to implement that clause 2.3 of the collective agreement, once again, all staff members are being dealt with. It records the agreement. And over the page, at page 32, it says, the effective date for payment of the remoteness and hardship allowance will be April 1, 2050. You cannot interpret that to mean that the incentive was terminated on that date. It wasn't. All it says is that's when we're going to pay the allowance. So with respect, and this document is dated the 7th of October, with respect in our submission, the judgment of the court R.Co. cannot be faulted. If you have reference to all 5 component parts of the documents making up the two agreements, the result in my respectful submission is clear. But if it could be said that there is relevant context apart from what I have referred to, which indicates, or to which the court can have regard, then there are 2 issues which we say serve as the context. One, it was clear that in 2010, the government had identified the need to incentivize qualified teachers to go and to remain at remote schools. Plainly, that was the purpose and that was the context. There's a need to have qualified teachers go to remote areas and to serve in those schools. And once they've got there, to stay. That was what that incentive sought to address. That was the background information, which is relevant. The second part is that it's quite plain that C1, the second issue is that C1, being the Prime Minister's letter, wasn't part of the context. It's part of the contractual matrix, as I've indicated. But then, if you go to the 2012-2015 agreement, the only relevant context is, first of all, that we know the 2009-2010 agreement and its terms, insofar as related to qualified teachers only in remote areas, was known. The government knew that. If they wanted to take that away, they needed to address it specifically, and they didn't. They knew that the incentive was in operation, and they knew they were having to pay it, and they continued to pay it. The other factor is, I've indicated, the review. What we know is the government was going to review that incentive. It did review that incentive. And so to that extent, there was no suggestion that absent such a review, anyone could have thought that the incentive came to an end. Now, the appellant looks to documents dated after the conclusion of the addendum, after the 2nd of October, in order to try and introduce context. We say that's completely impermissible, and I'll take you to those in a moment. But there was one document that does have relevance, that could be taken into account, and that's, for what it's worth, and that is the NANTU letter of the 6th of October. It's at page 33. So, at page 33, you'll see that letter is dated the 6th of October, and if you turn back one page, you'll see that the addendum was signed on the 7th of October 2015, the next day. So on the 6th of October, the day before the government signs, the NANTU writes to the Honourable Prime Minister, and at the top of page 34, tells him, in terms, it is our reading of the above provision that the envisaged incentive is for all staff members, including qualified teachers. We therefore humbly request your confirmation of the regard. Our query is intended to ensure this incentive is not confused with the 2009 incentive, which was specific to qualified teachers and aimed at securing the service of qualified teachers, coupled with retaining them at rural schools. So they raise the specific issue. In the second paragraph, they say your clarification has inadvertently bearing on the pending negotiations between the parties. And they say, please respond. Now, what happens the very next day? The government signs the addendum. Now, in that situation, with respect, there's no room for the government to now argue they had a different intention. Quite plainly, the party they're negotiating with has told them, we understand it for good reason. We understand that this hasn't done away with our incentive, and the government then goes and signs. The fact that at page 35 and in November 2015, the Prime Minister replies and places a different interpretation on what happened and spells out what he thinks has happened is really quite irrelevant. It's inaccurate. The agreements don't say what he says, but over and above that. Then the remoteness allowance is dealt with at page 36 under the service benefits. Once again, this is a document which postdates by some time. The actual conclusion of the 2012-2015 agreement is very relevant. But it is interesting that if you have reference to the purpose of the allowance, it's specifically called a remoteness allowance on page 36. It says under the heading purpose, paragraph 1, a remoteness and hardship allowance is paid to a staff member stationed at a duty station in an area specified as remote in recognition of the hardship he/she endures as a result of the limited availability of basic services, amenities, and infrastructure. That's a very different purpose to the purpose of the incentive in its express language as formulated to the extent the court should have regard to. Now, the fact that at page, my learned friend pays heavy emphasis on this, at page 37, under the heading Guiding Principles General, the fact that there's a phrase there which is, in my submission, not only irrelevant but inaccurate, doesn't take the matter any further. And that, if you have reference to paragraph 5.2.1 at page 37, general. The working and living conditions of staff members at duty stations in remote areas are challenging, which tend to cause a certain degree of hardship. That's accurate. These challenges refer to the availability of various types of services. An incentive recognizes this, and then this is the inaccurate statement, and encourages staff members to go to continue to serve in these areas. There's no suggestion anywhere, apart from this irrelevant statement, that the allowance was to encourage staff members to go there. In fact, almost certainly the cleaners, the handymen, the various categories of government employees, apart from teachers, who are there, are almost certainly drawn from that community. So to that extent, we say that fact that there is an inaccurate statement contained in a document, which overall, in truth, is positive, doesn't help the appellant in the slightest. And not only that, but it's interesting to see. Sorry, I was getting to a slightly different point. Not only that, but if you turn to page 38, there's an interesting little thing in the tail under the heading of sustainability. It's paragraph 5.2.4. And it says the remoteness allowance can be reevaluated. So to the extent that this allowance is no different to the incentive, it too can be reevaluated if you satisfy the provisions of the staff rule as articulated. It didn't, and it couldn't have been suggested. This allowance also terminated at the end of an arbitrary period of 1 year or two. And if you go on to page 39, you'll see 5.4.1. The remoteness allowance is a flat rate and is payable to all staff members stationed at a particular duty station. All staff members stationed at a particular duty station, very different to the incentive. And if you have reference to page 5.5, page 40, paragraph 5.5.2, you see there's also a reference to review. And then if you go to page 44, what you find here is the letter from the Office of the Prime Minister, dated 26 February 2016, equally an irrelevant document, but it is important to note that it's headed Introduction of New Public Service Staff Rule. It's not the extension of a rule, it's introduction of a new Public Service Staff Rule on remoteness and hardship allowance. So the third line of paragraph 1, it sets out that the rule is being granted. Third line, for the introduction and implementation of the Public Service Staff Rule. The introduction of the staff rule stems from the collective agreement entered between the government and the two recognized trade unions on 10th of October 2015, in terms of which an agreement was reached to introduce a remoteness allowance in the public service retroactively from 1st of April. Now, with respect, in our respectful submission, you can't find any indication that from any of these documents that in fact what the government sought to do was to replace for a qualified teacher the incentive they were getting in any event for an allowance.
Mr. McWilliam, how much time do you need? We're almost into lunch.
I probably need 10 minutes.
10 minutes. Yes, you may proceed.
Is your lordship addressing me? I couldn't hear that, I'm afraid.
No. I was addressing Mr. McWilliam. Just to find out how much time he needs, because we are into lunch. I don't know how much time we need to reply.
My lord, I anticipate 10 to 15 minutes maximum.
10 to 15 minutes. Okay. I think we'll be able to see and finish. Thank you. Mr. McWilliam, you may proceed.
Thank you. Now, the reason I indicated that I would be quick is because I simply want now just to canvass certain of the issues in my heads, which are before you and which I'm not going to read to you, but which are plainly relevant, because I've dealt with most of it. But what I specifically want to touch on is the section which I start at page 7 of our heads, dealing with the relevant legal principles. And why I want to pause there, and I'm not going to read you the extracts, but why I want to pause there is my learned friend indicated he has no authority for the proposition as to his argument in support of what he or how he interprets a collective agreement. And he said, he was asked, I can't remember by which of the judges, the lords, but there is authority. Because clearly what happens, and that authority is the authority which it starts really in paragraph 16, where the first, it's recorded that the arbitrator, that neither the first respondent nor the appellant disputed the fact that the 2009 incentive became a condition of employment, and that's accrued as a right of the employee. It's not in dispute, not dealt with in there, not challenged at any stage. Then, and you'll see we refer to section 51E of the Labour Act, and then we quote Andries Sanjenka, whose Transnaval Holdings, where your Lordship, Justice Hoff, handed down the judgment and deals with the passages from Parker. And specifically in paragraph 21, the Samwood case, to strike that the terms of a collective agreement are not only binding on individual employees, but as a matter of law incorporated into the employee's contract of employment. It's therefore my view that though the 2006 collective agreement lapsed its provisions, having been incorporated into the employment contracts of the individual members of the applicant, continue but not beyond the lifespan of the collective agreement. In and of itself, with respect, that finding by the court or quote, these authorities are decisive in our respect to submission of this issue. And we see no authority quoted by our learned friends which in any way detracts from this, these cases. I can indicate to you that in paragraph 22, the first paragraph quoted came from the head note. For some unknown reason, we incorporated as part of the quotation. It's the second paragraph, which is in fact the quotation from the judge. Now, insofar as the approach to the interpretation of documents are concerned, our learned friends and ourselves are in agreement as to what the approach that should be taken. We quote the judgment of this court in total Namibia, but nothing in our respective submission turns on it. I can also indicate to you that in footnote 32, that page reference which we quoted from the court of quote, in fact page 31 and not 30, the page reference to Parker. Now, we then deal with all the issues that I've now addressed thus far in argument, all the way up to page 32. And then in paragraph 87, we deal with the context to which, in addition to the factors that I've mentioned in oral argument, we touch on. Place emphasis on. And then, so far as the conclusion is concerned, our argument, the appeal should be dismissed with costs. Between the cost of two instructed and one instructing counsel, we're in agreement with our learned friend in this regard that the cost should follow the result in this court. My Lords, I've reached the end of my address, unless any questions that your Lordships wish to pose to me, but it strikes me, I do have perhaps a request, and that is if I could just have an opportunity to ascertain whether my junior and instructing attorney, if there's anything specific they want me to revert to.
Yes. Yes, we'll give you that opportunity.
We don't need to adjourn, do we? Can you just?
They're listening, and they can communicate with me by WhatsApp. So
Yes.
if I could just have a few moments for them to then formulate their thoughts and let me know whether there's anything specific. The only message I've had thus far, which I haven't necessarily attended to, is they wished me to quote from His Lordship Mr. Justice Hoff's judgment, which I have now done, which is dealt with in our heads. That I don't need to reiterate that. So that I've done. No, I have no further submissions.
Thank you. Mr. Butlander, in reply.
Thank you, my lord. My lord.
If I interrupt, would you like me to turn my camera off?
It might help.
It might help, yeah.
Lords, I have a number of points in reply. I'll try to organize them so that I'm not repetitive. The first point is are your lordships hearing me?
Yes, thanks.
The first point is our learned friend says that the two measures, the 29/10 measure and the 2012 measure is different. Measures are different. But with respect, that's an assertion without any explanation of why they're different. I've shown your lordships that the 2012 agreement in terms describes itself as a provision of an incentive allowance. Now, what is an incentive? Why are you giving an incentive to people at remote areas? The obvious reason you're giving them an incentive is to encourage them to work there. And so there's no difference in the purposes of the two. One is called an incentive and the other is called an incentive allowance. There's absolutely no distinction between the two. And our learned friend has failed to explain to your lordships what is the incentive which was provided by the 2012 agreement if it wasn't an incentive to go and work and stay at remote stations. A learned friend says that it's only for people who are already there. But if you wanted to pay an incentive to people to go there, how would you do it? You would say, I'll pay you an incentive if you work there. In other words, you pay the incentive to the people who are stationed there. You don't pay them in advance and say, I'll bribe you to go there. If you go there, if you're stationed there, you'll get an extra allowance. And that's the incentive. And so the incentive is an incentive to take up employment and remain there. That's why the incentive is paid to people who are stationed there. Whether they were there last week or whether they're there next week. Once you're stationed there, you get paid the incentive. So my learned friend, with respect, is unable to explain what the difference is, and the reason is that there is none. He then made a great effort to show your lordships that the 2012 agreement doesn't say anything is taken away from the teachers at remote areas? Well, of course it doesn't, because nothing was taken away from the teachers at remote areas. They had the allowance and they continue to get the allowance. So there was no need for the 2012 agreement to say we are going to take away the existing allowance and do what? And give it back again in the same breath. It would be entirely meaningless. The point is that nothing was taken away. What happened was that something was added. What was added was an improvement. The improvement was it now applied to everybody. And so the repeated statement that nothing could be taken away or was taken away is, with respect, somewhat circular, because we don't allege anything was taken away. The government's position is that it continued to pay exactly what it had, but it now extended this provision to other people. And that was a new system under the public service rules, and that's why it's described as a new rule. As opposed to an ad hoc arrangement which had been made in a single collective agreement between the teachers and the government. My learned friend then says, well, the terms of a collective agreement become part of the terms of and conditions of employment. That is so. We don't dispute that. But the question is this. My learned friend says that the first agreement must be paid as well as, I beg your pardon, the first incentive must be paid as well as the second incentive, because the first one is freestanding. You can't take it away. But he hasn't explained why, if that is the case, if the first agreement gives you $15,000 a month and the second agreement gives you $18,000 a month, why you're not entitled to $33,000 a month. And you're not, because the second agreement supersedes the first agreement. And what's in the first agreement is effectively incorporated. And it's really quite a remarkable proposition that something provided for in an agreement persists, in a collective agreement persists forever and is unaffected by subsequent collective agreements dealing with exactly the same matter. And that's the distinguishing feature of this case and the case in which my learned friend replies, the case in the South African Labour Court, the Samwu case. In the Samwu case, the second agreement didn't deal with one of the matters which had been dealt with in the first agreement, with shift allowances. And so the question was whether the shift allowances continued. And Judge Molachlehi found that they did continue because they were incorporated in the contract of employment. Or that may or may not be correct, but it's entirely irrelevant to this matter, because in this matter, the second agreement does deal with the matter which is in the first agreement, just as it deals with salary, just as it deals with transport, just as it deals with all sorts of things. And what it does is it supersedes what is in the new agreement, supersedes what is dealt with in the first agreement, where it's a matter which is dealt with in both. That's how collective agreements work. One doesn't need authority for that proposition. One knows that that's how they work, that the old agreement takes over, the new agreement takes over where the old agreement left off. Then my learned friend made some play of he told your lordships that the question of lapsing of the 2009 benefit was never before the commission, the Labour Commissioner. But with respect, that's not correct. Can I show the members of the court what actually happened? It's in volume 3, page 286, if I have the reference right. Yeah. This is what happened before the Labour Commissioner. It's page 286. It's the judgment of the Labour Commissioners under paragraph 5, analysis of evidence.
The page again?
286, my lord.
Yes.
What is said there, paragraph 5.2, this is one of the issues identified, which was before the commissioner, whether the 2009 agreement has been complied with, and how and when did the 2009 agreement and incentive come to lapse. And then a few lines down at line 26, the second paragraph under that heading, the Commissioner says, when having further regard to when the 2012 agreement, which was negotiated on, obviously in the year 2012, it's conclusive that the 2009 agreement only pertained to the 2009-10 and 2010-11 financial years. Hence the contention by the respondent that it fully complied with the 2009 agreement in that the qualified teachers up until before the 2012 agreement came into effect was continuously receiving their incentives as per the 2009 agreement. Thus, I'm of the honest view, taking into regard the testimonies and documentary evidence adduced, that the respondent did comply with the 2009 agreement, and furthermore, the 2009 agreement came to lapse after the respondent complied with it and coming into the effect of the 2012 elective agreement. So I don't understand my learned friends with submission that lapsing wasn't an issue before the Commissioner and is now only invented before your lordships. It was there from the outset. Then my learned friend seems to say, I'm not sure whether this is his submission, but he seems to understand our contention to be that the payment of the incentive terminated in March 2011. That's not our case. We say the payment was made under the 2009-10 agreement until March 2011. Thereafter, it continued in terms of the provision of the 2010 agreement, because that provided that it would continue to be paid after the agreement, the MOU had come to an end. And thereafter, it was incorporated in the 2012 agreement. So we have the same incentive or incentive allowance, call it what you will, being paid at all times. First under the MOU, then after the MOU, under the government's undertaking in the 2010 agreement, and then after that in the 2012 agreement. So to show that people continued receiving the incentive with respect takes one nowhere. Of course it continued. That's the government's case. It's difficult with respect to understand, if I then come to the Stellenbosch review, it's also difficult with respect to understand my learned friend's submission that the Stellenbosch review was part of the background information, which enables you to interpret the 2009, 2010, and 2012 agreements. The Stellenbosch review hadn't been completed by that time. It wasn't background information, which was before the negotiators in 2009, 2012, 2009, 2010, or 2012, because it hadn't been done yet. And so it can hardly be part of the background information. Talking of other documents, I have to say that my learned friend's submissions on the public service rules are utterly inconsistent. He refers to 5 paragraphs in that document, in the rules. He says 4 of them support him, so he can rely on them, and your lordships can have regard to them in interpreting the 2012 agreement. But 1 of them is against him. He says, answer to that is, oh, well, that one's wrong. And anyway, this was after the agreement was concluded. So you can't have regard to that. Well, it's all or nothing. Either the public service rules are relevant to interpreting the agreements and what was done, or they're not. We say that the government's statement in the rules is a clear indication that this was an allowance, which was an incentive to get people to go to these areas and to get them to stay there. But I don't need that. I don't need that because, as I've shown your lordships, the 2012 agreement itself says that this is an incentive allowance. The 2012 agreement, which is at page, let me just find it. It's Exhibit D, and it's at page 2.3, I beg your pardon, page 28, paragraph 2.3. It's headed Incentive for Remoteness and Hardship Areas, the introduction of an incentive allowance for staff members stationed at duty stations. Now, what my learned friend failed to explain to your lordships is what is this incentive that is different from the original one. If it's not an incentive to get people to go there and work there and stay there, what was the incentive? And it's only capable of one incentive, well, one meaning, which is to encourage people to work in the public sector at a place which is sometimes harsh and inhospitable as far as services are concerned. That's the incentive, and that, of course, is exactly the same incentive as was provided for in the 2009 MOU. I'm nearly done, if I can then come back finally to the point that my learned friend says the 2012 agreement doesn't have anything to do with taking away. But I repeat, the 2012, it's not our case that the 2012 agreement took anything away. Our case is that the 2012 agreement incorporated the existing undertaking to pay the incentive on a monthly basis. It incorporated it, and it created an innovation in providing the same benefits to everyone in the public service working in remote areas. It is not our case that anything was taken away, and there's no need to look in the 2012 agreement for something taken away, because nothing was taken away. All that happened was that just as the 2012 collective agreement said, your salary will no longer be X, it'll be Y. You can't claim X plus Y, you can now claim Y. Just so, the collective agreement said there will be the 2012 agreement said there will be an incentive for remote areas, and it will apply to everybody. Not those people who had it already can claim it again and twice. That would be a most extraordinary intention if one would need some explanation of why teachers were really the guinea pigs in this innovation. For 2 years, they received it, and government waited to see whether it provided benefits, and it did seem to provide benefits, and it was then extended to all. But there's no suggestion anywhere in the papers that government intended, ever agreed, and could ever have agreed to say teachers alone, not doctors, not clerks, not nurses, not police officers, not cleaners, not building workers. Teachers alone get a double incentive. They get an old incentive from 2009, and they get the new incentive, which everybody is getting. And what is more, that old incentive continues forever. It continues notwithstanding the 2012 agreement. It will continue notwithstanding the 2017 and 2022 agreement. It's a lifetime incentive, because they can just say we don't agree to abandon it, and then they've got it. That would be a most extraordinary result, notwithstanding any collective agreements which follow. Notwithstanding, no, let me put it this way, my lords. Let's assume that in the next collective agreement, if the incentive, the general incentive allowance is increased by 50%. What our learned friends and the unions agree to that. What our learned friends say is that by agreeing to an increased allowance, we're not agreeing to abandon the allowance we already had. Well, that's like saying, because I've got an increased salary, I'm not abandoning the salary which I already have. I want both the salary I bargained for in 2009 and the salary which I bargained for in 2012. With respect, that can't be so. The reliance on the correspondence is again extraordinary. Learned friend wants to rely on the letter written by Nantu, but he says your lordships can't have regard to the letter the Prime Minister wrote in reply. Well, that's a most extraordinarily one-eyed attitude to the documentation. Either the letter and the reply are relevant, or neither the letter nor the reply is relevant. And I ask your lordships to read the letter which the Prime Minister wrote. I'll take your lordships there. It's at page 35. It's unfortunately not a very clear copy. There's a better copy in volume 1 at page 38. Your lordships will go to volume 1, page 38. That's exhibit G. That's the letter which a learned friend doesn't, that's the reply which a learned friend doesn't want your lordships to be allowed to read. Your lordships only read the letter to which it is a reply. And this is what the Prime Minister says. She refers to the letter dated 6th of October 2015. That's the one that your learned friend wants your lordships to read. Then she says, the interpretation of the two agreements, 2009 and 2012, is that the 2012 agreement sought to extend the incentive awarded to teachers in 2009 to all staff members stationed at duty stations, classified as remote and hardship areas, thus harmonizing the two incentives into one. The purpose of the two incentives is to attract and retain staff members in public service into remote rural areas. Therefore, both incentives were tailored to address the same concern, namely the employer's concern relating to the attraction and retention of staff members in rural remote areas. I wish to therefore inform that I'm in agreement with your interpretation that the envisaged incentive is for all staff members, including qualified teachers, and further, that the 2009 incentive for qualified teachers lapses on the implementation of the 2012 incentive. And finally, when did the 2009 incentive lapse? We submit that there are two possible interpretations. One is that it lapsed in March 2012, when the MOU came to an end, but the incentive continued thereafter to be paid in terms of paragraph 1.3 of the 2010 agreement. That's one interpretation. It lapsed when the MOU came to an end. We submit that's the correct interpretation. It lapsed, but it was renewed by paragraph 1.3. The alternative interpretation is it continued under the 2010 agreement until the 2012 agreement was concluded. An agreement dealing with exactly the same matter, in exactly the same terms, but extending the benefit to those people. At that stage, the 29 benefit lapsed because it was incorporated in or superseded by the terms of the 2012 agreement. And, my Lord, those are our submissions.
Thank you. Are there any questions? Thank you. On behalf of the court, I want to thank both of you for your heads and your oral arguments. I also want to thank our staff who works so hard to make this hearing possible. The judgment is reserved in this matter. Over to Rajan.